like, who is this Mickey Truth girl? Who qualifies her to put a work on these people?
Hey,
Yeah, I'd rather be real than street any day.
What's up, y'all? It's your girl, Mickey Truth, aka the Queen of Paperwork, and I am back with another video. As always, all information contained in this video is for entertainment, educational purposes only. All information used in this video is per the Fair Use Act, and any conclusion that you draw is on you, not me. So let's get it. All right, y'all. So a lot of the motions that have been filed are now becoming orders, meaning the judge have made a ruling. So with that being said, the order for this particular one says defendants Christopher Thomas and Charles Liggins filed a motion to exclude expert testimony regarding firearm toolmark analysis, which is docket number 246. The motion is denied. The government's toolmark expert will be permitted to testify subject to the limitations set forth below. This is very important because anytime we're talking about a murder that happened with a firearm and something with the firearm is allowed to stay on record, then that's not going to be the best for the defendant. I mean, this is just assuming it actually will come out to be a match, right? So the background. Defendants Thomas and Liggins are awaiting trial on murder and conspiracy charges stemming from the shooting of FBG Duck and two other persons on Oak Street in Chicago, allegedly as members of an alleged criminal enterprise known as Oblock. The government intends to call Karen Tucker from the Illinois State Police Forensic Science Command to testify as an expert regarding firearm and toolmark comparisons that were conducted on firearms and casings. Okay. Toolmark analysis is premised on the theory that tools used in the manufacture of firearm leaves a distinct marks on various firearms components, such as bullets and casings. The distinct marks are called toolmarks. Okay. Now I do know I'm talking a little fast. However, I'm trying to get this done before I go to work. Nevertheless, this just means when a bullet is released from the chamber of a gun, according to the toolmark analysis, it's going to leave an impression on that bullet so that they can match the shell casing to a gun if they are able to find the actual gun, or if they have multiple bullets or shell casings, they can match that they came or were fired from the same gun based off of these tool marks. Okay, now we're going to continue on. It is, again, this says here, toolmark analysis is used to distinguish between the second and third categories in essence to determine whether a bullet or casing was fired from a particular firearm. Boom, dang, I gave a good description of that one, okay? Now, this is what they're saying. Several casings were found on the ground on Oak Street, and another casing was found in the windshield well of a vehicle that had allegedly been at the scene of the shooting, which is also in 246. The firearm was found in a separate location and analyzed against the casings. Ms. Tucker is expected to opine on the general operations of firearms, about the firing process and the effects of high pressure system inside a firearm barrel on the fired bullet and cartridge, about toolmarks, how they are made and what they mean. And it continues on what she's going to say. Okay. Now, this is important, right? The conclusions, okay, that Ms. Tucker, who is the expert, is going to say at trial, according to this is that 6 cartridge casings recovered from the street near 70 East Oak Street were fired from the same recovered pistol as to which she tested fired test rounds. Okay. 2, that she would not expect another firearm to make the exact same marks identified on a shell casing or bullet. Okay, at 3, that certain shell casings and or bullets were fired from the same firearm. The government has stated that she will not express her conclusions are absolute or made with 100% certainty. Defendants Thomas and Liggins moved to exclude Ms. Tucker's opinions on the ground that toolmark analysis is unreliable. Now, I will say this. In many cases that I have covered over time as a content creator and offline, right, they use bullet analysis or toolmarks. This is the first time I heard it called toolmarks, okay? However, a lot in many cases matching the shell casings to the firearm. So that is I would say it was a reach, but hey, when you're fighting for your life, hey, file all the motions. But I'm not surprised they denied the motion. Okay. Now, again, it says as far as legal standing, expert testimony is governed by Rule 702. A person may testify as an expert under Rule 702 if one, her testimony will help the tier of facts to understand the evidence or to determine a fact and issue. Two, her testimony is based on sufficient facts or data. Three, her testimony is a product of reliable principles and methods. Four, she has reliable applied the principles and methods to the facts of the case. And like I said, they have been using this forever and ever and ever as far as bullet casings and firearms. Okay. Now, the discussion here, I'm going to go down, is that the defendants challenged the reliability of Ms. Tucker's testimony and argue that firearm toolmark analysis is unreliable and inadmissible. They also argue that the procedures in this case were unreliable because Ms. Tucker was given unnecessary details prior to her analysis. Defendants do not challenge Ms. Tucker's qualification. The Seventh Circuit has affirmed a district court admission under Rule 702 and debut of expert toolmark analysis testimony based on the Association of Firearms and Toolmark Examiners methodology. Okay, they always be throwing all these doggone big words. Okay, the court reaches a similar conclusions in the case law that they placed here. Right now, they continue to go on stating that Ms. Tucker applied her knowledge of AFTE with reaching her conclusions, meaning she stayed within the scope of what they look for. Also, they already had a previous incident where potential error rate is acceptable for the AFTE methodology. Okay. Now, it also says whether the method has been subject to peer review. The next factor is whether or not it's been subject to peer review. Defendants do not argue that it has not been peer reviewed. So instead, they highlight publications that critique the AFTE method. Anytime you argue any type of case law, it's always going to be case laws that's going to go for it, case law that's going to go against it. And it's always going to be just like, again, with YouTube videos. You may have some videos that go towards one way and some videos that go towards another way. But at the end of it is what has the most factual basis and what has been used over and over again, right? You can't just come out of thin air and say, hey, the sky is purple. But over the years and times, the sky has been blue. You get what I'm saying? I know that might be a bad analogy, but however, I'm trying to give y'all an example. Okay. Now, let's continue on. Defendants argue that AFTE has no objective quantitative standards for identifying a match. Again, this has been used so many times. Okay. And this is what they're saying is their rebuttal to that. This sufficient agreement is related to the significant duplication of random tool marks as evidenced by a pattern or combination of patterns of surface contours. Okay. And it goes in more. Y'all may not want to hear all that, but basically saying, hey, we have done enough on this where we know the toolmark analysis of a casing will match the firearm that it came from. And in their case, right, on the flip side, regardless what they're stating, the fact that they recovered a firearm, it matches the shell casings in this case, like it was a reach, right? Now, it would have been one thing if they had a whole nother weapon, fired the bullets, and then they match, and that weapon would say like a police weapon, and you like, okay, see, it don't even, you know. But again, at this point, try everything you can. So, how I'm taking the whole overall conclusion is that the motion was denied because it met every purpose of the outline that needed to be met, meaning how they went about getting the findings, how they provided case law, all that. So with that being said, that's it. You know, it's a no-go. Now, it's going to be a matter of how the defense attorneys attack whatever is provided in the testimony of Ms. Tucker, but we'll know soon enough because on October 13th, 2023, Oblock Rico trial is scheduled to begin. So with that being said, make sure you like, comment, share, subscribe, tell a friend, and pull up on your girl Mickey Truth. And as always, go over to MickeyTruth.com and get you that merch because you know your girl stay with that work. So until next time, holla.
Who qualifies her to put a work on these people? Hey, yeah. Not by views, so you know they doubted me. Yeah, you got exposed cause you know you wrong. If you never told what you were for,